Case 1. Nancy Moronez. Franklin and Milwaukee, Milwaukee County, Wisconsin. March 29, 1980, February 15, 1985. In the spring of 1980, Nancy Moronez was a young mother living in Franklin, Wisconsin, a suburban community in Milwaukee County situated just south of the city of Milwaukee. She had recently given birth to a son named Justin Brunke. Justin was 18 days old. On March 29, 1980, Justin Brunke was reported to have died. The cause of death recorded at the time was sudden infant death syndrome, commonly referred to as SIDS. In the medical community of that era, SIDS was a frequently applied explanation for the unexpected death of infants in whom no immediately obvious cause of death could be identified. It was, in many ways, a diagnosis of exclusion, a conclusion reached in the absence of other findings, rather than through the presence of definitive physical evidence pointing to a specific cause. The forensic pathology available in 1980 did not yet include many of the analytical tools that would later allow medical examiners to distinguish more reliably between SIDS and other causes of infant death. Justin's death was recorded, mourned, and in the absence of further investigation, closed. For years past. During those 4 years, Nancy Moronez continued to live and work in the Milwaukee County area. She had, in the community, a reputation as someone willing to provide childcare. That reputation placed her in a position of responsibility over vulnerable infants. Infants who, by definition, were entirely unable to protect themselves or to communicate their circumstances to anyone outside the home. In 1984, Nancy Moronez was living in Milwaukee, Wisconsin. She had established herself as a babysitter and caregiver in her community. A 6-month-old infant named Brad Stige was placed in her care by his family. Brad Stige subsequently died while under her supervision. As had happened 4 years earlier with Justin Brunke, the death of Brad Stige was attributed to sudden infant death syndrome. The investigation conducted at the time did not produce findings that pointed toward any cause other than SIDS. The case was closed. Less than 1 year later, on February 15, 1985, a 3-month-old infant named Katie Kozaniecki died while in Nancy Moronez's care in Milwaukee. The cause of death was once again recorded as sudden infant death syndrome. A third death. A third SIDS determination. A third family left without a full accounting of what had happened to their child. 3 infant deaths. 3 SIDS determinations. 3 families. 3 cases, each individually closed, with no connection drawn between them at the time. For more than 3 decades, that is where the record stood. The 3 deaths were not connected in any active investigative file. They were not the subject of any ongoing law enforcement scrutiny. They existed as 3 separate, closed cases in the records of Milwaukee County, historical data points rather than open investigations. The case did not resurface through the work of law enforcement alone. It resurfaced because of a family member. In 2015, 30 years after the last of the 3 infant deaths, Nancy Moronez's adult daughter came forward and made a disclosure to law enforcement. The nature of that disclosure was sufficient to prompt investigators to take her account seriously and to reopen an inquiry into all 3 infant deaths. The decision to reopen a case that was 30 years old, involving 3 separate deaths and 3 separate SIDS determinations, was not a simple one. It required the involvement of multiple law enforcement agencies and prosecutorial offices. It required a forensic review of historical records, original medical examiner reports, hospital records, case files from the 1980s, under the light of current forensic knowledge. And it required prosecutors to assess whether, given the evidence available, a criminal case could be made that would meet the legal standard required for prosecution. Evidence sufficient to prove guilt beyond a reasonable doubt. The cold case investigation that followed the 2015 disclosure was thorough and careful. Investigators examined the circumstances of each of the 3 deaths separately and as a pattern. The statistical improbability of a single caregiver being present for 3 separate SIDS deaths was one element of the analysis. The specific physical evidence and the accounts of individuals with knowledge of the circumstances surrounding each death were also examined. The investigative work was conducted over a period of years before charges were brought. After that thorough review of the evidence, charges were filed against Nancy Moronez in Milwaukee County. The legal proceedings that followed were extensive and carefully documented through the Milwaukee County Circuit Court. On a date in February 2019, Nancy Moronez entered a plea of guilty in Milwaukee County Circuit Court to 3 counts of homicide by reckless conduct, 1 count for each of the 3 infants who had been in her care and who had died. The guilty plea represented a formal judicial acknowledgement of her legal responsibility in the deaths of Justin Brunke, Brad Steege, and Katie Kozaniecki. Under Wisconsin law, homicide by reckless conduct is a Class D felony, defined as the act of causing the death of another human being by conduct that creates an unreasonable and substantial risk of death or great bodily harm. Sentencing took place on May 3, 2019, in Milwaukee County Circuit Court. The court sentenced Nancy Moronez to 30 years in state prison, 3 consecutive terms of 10 years each, 1 for each count of homicide by reckless conduct to which she had pleaded guilty. The structure of the sentence, consecutive rather than concurrent, was significant, as it meant that the 3 terms would be served one after the other rather than simultaneously, resulting in a total minimum prison term of 30 years. At the time of sentencing, Moronez was in her late 50s. The practical effect of a 30-year sentence imposed at that age is substantial. It means she would be in her late 80s before becoming eligible for release under the terms of the sentence, assuming it were served in its entirety, without modification. The case of Nancy Moronez is significant for several reasons that extend beyond the specific facts of her prosecution. First, it demonstrates the long-term evidentiary value of a family member's willingness to cooperate with law enforcement. Without the 2015 disclosure by Moronez's daughter, it is probable that the 3 deaths would have remained permanently in the closed files of Milwaukee County as SIDS cases. The daughter's decision to come forward, whatever its personal cost, whatever the family dynamics that shaped it, was the act that made the legal process possible. Second, the case illustrates the way in which historical cases can be revisited and successfully prosecuted decades after the underlying events occurred. The 35-year gap between the first of the 3 deaths in 1980 and the guilty plea in 2019 is a testament to the principle that the passage of time does not extinguish legal accountability, provided that sufficient evidence can be assembled to support a prosecution. Third, and perhaps most importantly for the broader context of child welfare and forensic medicine, the case highlights the extent to which the diagnostic framework available to medical examiners in the 1980s, specifically, the broad application of sudden infant death syndrome as a cause of death, was sometimes insufficient to identify cases that warranted further inquiry. SIDS is a real and recognized medical phenomenon, but its widespread application as a default explanation for unexplained infant death in the 1980s and earlier meant that some cases that might have been investigated as potential homicides were instead closed as natural deaths. The medical and forensic communities have, in the decades since, developed more rigorous and detailed protocols for the investigation of unexpected infant death specifically to address this concern. The Moronez case is one of the Wisconsin examples that informed and illustrated the need for those reforms. Fourth, the case demonstrates the functioning of Milwaukee County's prosecutorial infrastructure in addressing very old cases. The decision to prosecute requires not only evidence, but institutional will. The willingness to commit the resources, the time, and the reputational investment to a case that might not succeed, and that will certainly be difficult. The Milwaukee County District Attorney's Office made that commitment, and the result was a 30-year prison sentence. The 3 infants at the center of this case, Justin Brunke, Brad Steege, and Katie Kozaniecki, each lost their lives before they reached the age of 1 year. All 3 were placed in the care of a person their families trusted. All 3 families waited more than 30 years for the legal system to formally address what the court ultimately determined had happened. The 30-year prison sentence handed down on May 3, 2019, in Milwaukee County Circuit Court, was that system's answer. It was a long time coming, but the record of the Milwaukee County Circuit Court shows that it came. If you found this case significant, please take a moment to like this video and subscribe to Cold Case Hour for more verified, in-depth Wisconsin case coverage. Your support keeps this work going, and these stories being told. Case 2, Taylin Hill, Dane County Circuit Court, February 2007. Fitchburg, Wisconsin, is a city of approximately 30,000 residents located in Dane County, directly south of Madison, the state capital. It is a community largely characterized by residential neighborhoods, research parks, and proximity to the University of Wisconsin campus and the governmental and educational infrastructure of one of the Midwest's most prominent state capitals. Dane County is, in many respects, among the most well-resourced counties in Wisconsin in terms of its law enforcement, prosecutorial, and social services infrastructure. In February of 2007, Fitchburg was the location of a case that would not reach its legal resolution until nearly a decade later, a gap that raises important questions about how cases involving concealed deaths and transported remains are identified, investigated, and ultimately prosecuted. Erica Hill was 15 years old. She lived with her mother, Taylin Hill, in Fitchburg. 15 years old is a particular kind of vulnerable, old enough to appear to others as someone capable of looking after herself, but young enough to be entirely dependent on the adults in her life for housing, financial support, and the basic structures of daily existence. A 15-year-old who lives with a parent lives within the walls of that parent's home, subject to whatever conditions that home contains. She cannot simply leave. She cannot access the financial resources necessary to establish an independent existence. She is, in the most practical sense, dependent. In February 2007, Erica Hill died. Her death was not immediately reported to law enforcement. It was not treated, in the immediate aftermath, as a matter requiring notification of any medical authority, any law enforcement agency, or any family member or community member who might have raised questions. The circumstances surrounding Erica Hill's death were concealed, and her remains were transported out of the state of Wisconsin. The decision to transport remains across state lines is, from a prosecutorial standpoint, a complicating factor in any investigation. It removes the physical evidence from the jurisdiction where the death occurred. It potentially creates competing jurisdictional claims between the state where the death took place and the state where the remains were discovered. And it introduces a layer of deliberate concealment that, while it complicates the investigation, can also serve as evidence of consciousness of guilt and awareness on the part of the person who moved the remains. That discovery would lead to legal consequences. For years, Erica Hill was simply absent. There was no public report of a missing 15-year-old in Fitchburg. There was no immediate investigation. There was no open case. From the perspective of the official record, Erica Hill had effectively disappeared, and no person in a position of authority had been informed that she was gone. She was not listed as a runaway. She was not the subject of a welfare check. She was not reported to any missing persons database. She simply was not there, and no one in the official system knew to look for her. That absence persisted for approximately 8 years. During those 8 years, Taylin Hill continued her life in the community. The circumstances of Erica's death remained, as far as the public record was concerned, unknown. Whatever knowledge existed about what had happened to Erica Hill in February 2007 resided with individuals who had chosen, for whatever combination of reasons, not to bring that knowledge to law enforcement. The investigation into Erica Hill's disappearance and death was initiated and pursued through law enforcement channels that eventually, in September 2015, resulted in the arrest of Taylin Hill. The precise investigative pathway that led to that arrest, the specific agencies involved, the leads that were followed, the evidence that was identified and analyzed, the witnesses who were located and interviewed, is part of the public court record in Dane County and reflects the work of law enforcement professionals who committed to finding out what had happened to a girl who had been missing, officially, for years. The charges brought against Taylin Hill were serious. Prosecutors alleged that Erica Hill had been subjected to prolonged physical mistreatment in the period leading up to her death in February 2007, and that Taylin Hill was responsible for both the circumstances that led to Erica's death and for the deliberate and sustained actions taken afterward to prevent discovery of what had occurred. The concealment of remains and the transportation of those remains across state lines were themselves criminal acts, in addition to the conduct that had directly caused Erica's death. The case proceeded through the Dane County Circuit Court over the course of the following year. In July 2016, 9 years after Erica Hill's death, Taylin Hill entered a plea of guilty to reduced charges that included child neglect causing death, along with related counts. The plea agreement reflected negotiations between the prosecution and the defense and resulted in a guilty plea rather than a trial verdict. The use of a plea agreement in a case of this nature is not unusual. Plea agreements serve multiple functions in the criminal justice system. They provide certainty of outcome for both the prosecution and the defense. They avoid the risk of acquittal at trial. They reduce the burden on the court system. And in cases involving the death of a child, they spare the family members and other individuals with knowledge of the events from having to testify in open court about what they knew and when they knew it. In the Taylin Hill case, the guilty plea to reduce charges was the mechanism through which the legal system formally acknowledged her responsibility for Erica's death. Sentencing followed the guilty plea. Taylin Hill was sentenced to 20 years in state prison by the Dane County Circuit Court. The sentence reflected the severity of the conduct. A prolonged failure of care toward a minor child, followed by a sustained and deliberate effort to prevent law enforcement from learning what had occurred over a period of nearly 9 years. 20 years is a substantial sentence. But in the context of this case, 9 years of concealment, a 15-year-old child, prolonged mistreatment, it reflects a judicial determination that accountability required a significant period of incarceration. The case of Taylin Hill raises a series of issues that are common to investigations involving the concealment of a victim's remains. The absence of a body, or the removal of remains from the jurisdiction, significantly complicates prosecution in ways that extend beyond the jurisdictional questions. It eliminates or reduces the physical forensic evidence available to investigators. It creates gaps in the evidentiary timeline that prosecutors must fill through other means. Witness testimony, phone records, financial records, documentary evidence, and the statements of individuals who may have had knowledge of events at the time they occurred or in the years that followed. Building a criminal case under those conditions requires significant investigative resources and prosecutorial creativity. That Dane County prosecutors were able to build a case sufficient to obtain a guilty plea, nearly a decade after Erica Hill's death in February 2007. Reflects the persistence of the investigative process, the quality of the legal work performed by law enforcement and the district attorney's office, and the ultimate willingness of those with knowledge of events to participate in the legal process. Erica Hill was 15 years old. She lived in Fitchburg, Dane County, Wisconsin. She died in February 2007. The legal process concluded in 2016 with a 20-year prison sentence imposed by the Dane County Circuit Court, a sentence that, by the time it was imposed, came 9 years after the events that gave rise to it. The distance between those two dates, February 2007 and July 2016, represents the full span of the concealment, the investigation, the arrest, the charging process, the plea negotiations, and the sentencing. It is a span that speaks both to the complexity of the case and to the commitment of the Dane County legal system to reaching a conclusion on behalf of a young woman who had been absent from the official record for nearly a decade. If this case resonated with you, please like this video and subscribe to Cold Case Hour. Hit that notification bell so you never miss a new episode. Every like and every subscriber helps us keep covering these important Wisconsin cases. Case 3, Henrietta Rogers. Milwaukee, Milwaukee County, Wisconsin. February 10, 2022. Milwaukee is the largest city in Wisconsin and the seat of Milwaukee County. With a population of approximately 570,000 people, it is a city with a large and active court system, a substantial law enforcement infrastructure, and a long institutional history of prosecuting cases involving the welfare of children. The Milwaukee Police Department, the Milwaukee County Sheriff's Office, and the Milwaukee County District Attorney's Office collectively represent one of the most experienced and well-resourced criminal justice systems in the state. On February 10, 2022, that system was called upon to respond to a case involving a 10-year-old child named Jada Clay. Jada Clay was 10 years old and resided in Milwaukee. 10 years old means a child who is aware of the world, who has friendships and a school routine and opinions about things, who is old enough to understand when something is wrong, but not old enough to possess the power or the resources to address it. It means a child who is still fundamentally dependent on the adults around her, dependent not only for the practical necessities of food and shelter, but for the emotional and relational structures that make a child feel safe. On the evening of February 10, 2022, Jada Clay came into conflict with Henrietta Rogers. The exact nature and progression of the dispute, as established through the subsequent legal proceedings, reportedly originated over the issue of the child's hair being braided. An argument that began with something so ordinary and so domestic escalated in a way that ended with Jada Clay dead. Law enforcement responded to the Milwaukee address. The scene they encountered required both law enforcement response and medical emergency response. The circumstances of Jada's death were investigated by the Milwaukee Police Department, and the matter was referred to the Milwaukee County District Attorney's Office for review and charging determination. Henrietta Rogers was taken into custody. An investigation was conducted. The charge brought against Henrietta Rogers in Milwaukee County Circuit Court was first-degree reckless homicide under Wisconsin statutes. First-degree reckless homicide is a Class B felony in Wisconsin. It requires the prosecution to prove that the defendant's conduct caused the victim's death and that the conduct was carried out with utter disregard for human life. The utter disregard standard is a demanding legal threshold. It requires more than negligence or recklessness in the ordinary sense, and it requires the prosecution to demonstrate that the defendant's conduct reflected a culpable mental state that the law treats as among the most serious forms of homicidal conduct short of intentional killing. The decision to charge first-degree rather than second-degree reckless homicide reflects the prosecution's assessment of the evidence and the specific circumstances of the case. The Milwaukee County District Attorney's Office, in bringing this charge, made a legal determination that the evidence was sufficient to establish not merely that Rogers had been reckless, but that her conduct had reached the level of utter disregard for human life required by the first-degree statute. The case proceeded to trial. Henrietta Rogers did not enter a guilty plea. She exercised her constitutional right to trial by jury, a right fundamental to the American legal system, the exercise of which is neither evidence of guilt nor an aggravating factor in sentencing, but which in this case resulted in the presentation of the full body of evidence to a jury of Rogers's peers in Milwaukee County Circuit Court. The trial involved the presentation of evidence by the prosecution, physical evidence, forensic analysis, witness testimony, and the documentation generated by the law enforcement investigation. The defense presented its case and its arguments. At the conclusion of the trial, in May 2023, approximately 15 months after Jada Clay's death, the jury returned a verdict of guilty on the charge of first-degree reckless homicide. The verdict was the jury's formal legal determination, reached after deliberation, that the prosecution had proven its case beyond a reasonable doubt. The verdict triggered a sentencing proceeding. Sentencing in felony cases in Wisconsin involves the preparation and submission of a pre-sentence investigation report, the presentation of victim impact statements, and arguments from both prosecution and defense regarding the appropriate sentence. On August 11, 2023, Henrietta Rogers appeared before a Milwaukee County Circuit Court judge for sentencing. The court imposed a sentence of 25 years in state prison. The sentence reflected both the jury's determination of guilt on a Class B felony and the court's assessment of the appropriate punishment given the specific facts of the case, the circumstances of the victim, and the applicable sentencing guidelines. The case of Henrietta Rogers drew significant attention from local media and from child welfare advocates in the Milwaukee area. Jada Clay was 10 years old. The circumstances of her death, an altercation that escalated within a domestic environment over something as routine as hair braiding, are the kind of circumstances that child welfare professionals frequently identify as falling within a pattern of preventable incidents, situations in which a failure of conflict management, a failure of emotional regulation, and the unchecked presence of a child in a vulnerable position combine to produce a fatal outcome. The Milwaukee County prosecution concluded with a conviction following a jury trial and a 25-year sentence. That outcome took approximately 18 months from the date of Jada Clay's death in February 2022 to the date of sentencing in August 2023. The timeline reflects the thoroughness of the investigation, the complexity of preparing and presenting a jury trial on a first-degree reckless homicide charge, and the deliberate and careful pace at which a case of this magnitude moves through the court system. The Milwaukee County jury system functions as a cross-section of the community. People drawn from the jury pool who review the evidence, hear the arguments, receive the legal instructions from the court, and reach a verdict through deliberation. In this case, that process resulted in a verdict of guilty. 25 years. The sentence imposed on August 11, 2023, is a quarter of a century. It is a sentence that will keep Henrietta Rogers in state custody well past the middle of this century. For the record, the key dates in this case are February 10, 2022, the date of Jada Clay's death; May 2023, the date of the jury's guilty verdict in Milwaukee County Circuit Court; August 11, 2023, the date of sentencing. 25 years, the term of imprisonment imposed. Jada Clay was 10 years old. The legal system of Milwaukee County took her case through investigation, charging, a full jury trial, verdict, and sentencing. The result was a conviction on a Class B felony and a quarter-century prison sentence, a result that the court record reflects as the outcome of a thorough, professionally conducted, and constitutionally sound prosecution. Please like this video and subscribe to Cold Case Hour for continued coverage of Wisconsin's most significant legal cases. Share this episode with someone who follows true crime, and don't forget to hit the notification bell. Case 4. Natalia Alexandrovna Hitchcock. Sheboygan County Circuit Court. March 30, 2022. Sheboygan Falls is a city of approximately 8,000 residents located in Sheboygan County in eastern Wisconsin, approximately 60 miles north of Milwaukee along the Lake Michigan shoreline. It is a small, close-knit community in which the institutions of local government, the police department, the courts, the county social services offices, operate within a relatively tight geographic and demographic context. The community and its legal system were presented, in the spring of 2022, with a case of extraordinary legal and psychiatric complexity. On March 30, 2022, law enforcement in Sheboygan Falls received a call that set in motion one of the most carefully documented and legally nuanced prosecutions in Sheboygan County's recent history. The responding officers encountered circumstances that required the simultaneous engagement of law enforcement, emergency medical services, and the mental health response infrastructure of the county and state. The investigation that followed the events of March 30, 2022 was handled by the Sheboygan County Sheriff's Office and referred to the Sheboygan County District Attorney's Office for review and charging. The facts established through the legal proceedings that followed are a matter of public record. On that date, Natalia Alexandrovna Hitchcock's 8-year-old son, Oliver Hitchcock, sustained injuries at the family residence in Sheboygan Falls. Oliver subsequently died as a result of those injuries. Additionally, Natalia Hitchcock's 11-year-old son was involved in the same incident. An attempted homicide charge was initially included in the case related to the 11-year-old. However, in the course of the legal proceedings, that charge was dismissed as part of the plea resolution negotiated between the prosecution and the defense. The charges brought against Natalia Hitchcock in Sheboygan County Circuit Court were among the most serious available under Wisconsin criminal statutes. From the earliest stages of the case, however, the legal proceedings were shaped by questions that went beyond the factual circumstances of March 30, 2022. Those questions concerned the mental state of Natalia Hitchcock, not only at the time of the events themselves, but as a more general matter of her psychological condition and its relevance to her criminal responsibility under Wisconsin law. The intersection of serious criminal conduct and significant mental health conditions is one of the most complex areas of criminal law. Every legal system must grapple with the question of how to respond to conduct that would otherwise constitute a serious crime when the person who committed that conduct was, at the time, in a mental state so profoundly different from ordinary consciousness that the standard framework of criminal responsibility, which assumes a baseline capacity for rational decision-making and understanding of the consequences of one's actions, does not apply. Wisconsin addresses this question through the legal doctrine of not guilty by reason of mental disease or defect. Under Wisconsin statutes, a defendant may be found not guilty on this basis if the evidence establishes that, at the time of the offense, the defendant lacked the substantial capacity either to appreciate the wrongfulness of their conduct or to conform their conduct to the requirements of law. Both elements, appreciation of wrongfulness and capacity to conform, are framed in terms of substantial capacity, not complete incapacity. The law does not require that the defendant have been completely unaware of their surroundings or actions. It requires that their mental condition have substantially impaired one of these two fundamental capacities. Establishing a defense of not guilty by reason of mental disease or defect in Wisconsin requires a formal evaluation process. Court-ordered mental health evaluations are conducted by qualified forensic psychiatrists or psychologists. Those evaluations are submitted to the court, reviewed by both prosecution and defense, and may be the subject of competing expert testimony. The legal threshold is high, and the determination, whether made by a jury or, in cases resolved by plea, by the court itself, requires careful consideration of the specific clinical findings and the applicable legal standard. In the case of Natalia Hitchcock, mental health evaluations were ordered and conducted as an integral part of the legal process. The findings of those evaluations were submitted to the Sheboygan County Circuit Court and became central to the resolution of the case. Following the entry of a no-contest plea and a thorough review of the mental health evidence, the court made a determination consistent with the findings of the evaluation process. Natalia Alexandrovna Hitchcock was found not guilty by reason of mental disease or defect. On May 11, 2023, approximately 13 and a half months after the events of March 30, 2022, Natalia Hitchcock was committed to the custody of the Wisconsin Department of Health Services for the remainder of her life. The commitment order was entered by the Sheboygan County Circuit Court. It is critically important to understand what this legal disposition means and what it does not mean. A commitment to the Wisconsin Department of Health Services under the not guilty by reason of mental disease or defect statute is emphatically not a finding of innocence. The court's determination that Natalia Hitchcock met the legal standard for this defense is not a determination that she did not cause Oliver's death. The court proceedings established that she did. It is a legal determination that her mental condition at the time of the offense placed her outside the standard parameters of criminal responsibility under Wisconsin law. The distinction is legally significant and ethically important. The lifetime commitment imposed in this case means that Natalia Hitchcock will remain in the custody of the Wisconsin Department of Health Services indefinitely, in a secure treatment facility. Her placement is subject to ongoing review. Under Wisconsin statutes, she may petition the committing court for conditional release, but no more frequently than once every 6 months. Any petition for conditional release is subject to a full hearing before the court, at which the state has the opportunity to present evidence and argument regarding the risk she would pose to public safety if released. Release is not automatic, not presumptive, and not granted as a matter of course with the passage of time. It requires an affirmative judicial finding that the conditions that led to the commitment have changed in a manner sufficient to make conditional release appropriate. The practical effect of a lifetime commitment in a case of this nature is that the Wisconsin Department of Health Services has both the authority and the legal responsibility to maintain Natalia Hitchcock in secure custody for as long as her mental health condition and risk assessment require it. The treatment infrastructure of the department is designed to provide psychiatric care, monitoring, and evidence-based therapeutic intervention. Whether and when any petition for conditional release would be granted depends entirely on the clinical and legal determinations made at the time such a petition is filed. The outcome in the Hitchcock case illustrates the way in which the Wisconsin criminal justice system is designed to navigate the intersection of serious criminal conduct and significant mental health considerations. It is a resolution that does not fit neatly into the conventional narrative of prosecution, conviction, and incarceration, but it is a resolution that the law specifically provides for, that the court applied on the basis of professional clinical evaluation, and that imposes a form of permanent legal control over the individual's liberty. Oliver Hitchcock was 8 years old. He died on or shortly after March 30, 2022, in Sheboygan Falls, Sheboygan County, Wisconsin. The attempted homicide charge related to his 11-year-old brother was dismissed as part of the plea. The legal proceedings concluded on May 11, 2023, with the lifetime commitment of his mother to the Wisconsin Department of Health Services, a commitment entered by the Sheboygan County Circuit Court and subject to the continuing jurisdiction of that court. The Sheboygan County Circuit Court record in this case is detailed, carefully developed, and publicly available. It reflects the full complexity of a prosecution that required the legal system to address not only what happened on March 30, 2022, but why it happened, what it meant in terms of legal responsibility, and what the appropriate legal response should be given the totality of the circumstances established by the evidence. Those are not simple questions. The Sheboygan County Circuit Court answered them as carefully and thoroughly as the law requires. If you found this case informative, please like this video and subscribe to Cold Case Hour. We cover verified Wisconsin cases in full documentary depth, new episodes every week. Your subscriptions make this channel possible. Case 5. Ruby C. Klokow. Sheboygan County Circuit Court. 1957. Reopened 2008. Of all the cases covered in this documentary, the case of Ruby C. Klokow is the oldest. Its origins lie not in the 21st century, not in the 1990s, not even in the 1970s, but in the year 1957, a full 66 years before the most recent case in this collection. It is a case that tests the outer boundaries of what the legal system can accomplish, examines how long a case can remain actionable, and raises fundamental questions about what it takes, in terms of evidence, courage, institutional will, and the sustained commitment of individuals with knowledge of historical events to bring a decades-old matter to a modern courtroom. To understand the significance of the Klokow case, it helps to understand the legal and forensic landscape of 1957. The United States in that year was a country in which forensic science, as a formal discipline applied to criminal investigations, was in a relatively early stage of development. The techniques that modern viewers of true crime content take for granted, DNA analysis, advanced toxicological screening, detailed forensic pathology protocols for infant deaths, standardized procedures for the investigation of unexpected deaths in the home, either did not exist or existed in far more primitive forms than they do today. In this context, the death of an infant in the home, investigated by the standards of 1957, was frequently difficult to characterize definitively as either natural or the result of human action. The forensic tools available to medical examiners of that era were limited. The investigative protocols for sudden infant deaths were less standardized. The ability to distinguish between accidental, natural, and criminal causes of death in very young children was far more constrained than it would become in subsequent decades. In 1957, Ruby C. Klokow was a resident of Sheboygan, Wisconsin. She had an infant daughter named Janine, who was 6 months old. In that year, Janine Klokow died. The death was investigated by the authorities of the time, and the conclusion reached, applying the forensic and investigative standards available in the late 1950s, was that the death was accidental. No criminal charges were brought. No prosecution was initiated. The case was closed. Ruby Klokow was not charged. Life, as far as the official record was concerned, continued. Life did continue. Decades passed. The official record of Janine Klokow's death remained what it had always been, accidental. Ruby Klokow grew older. The children she had raised grew up, left home, formed their own families and lives, and carried with them whatever knowledge they had about the events of 1957. That knowledge, whatever form it took, whatever its specific content, was not shared with law enforcement for more than 50 years. The case was reopened in 2008. The catalyst for the reopening was a member of Ruby Klokow's own family, her son James. James Klokow came forward and made disclosures to law enforcement in 2008 that provided investigators with a fundamentally different account of what had happened in 1957. What he told investigators, and what investigators subsequently determined was sufficient to support a criminal prosecution, was that the death of Janine Klokow in 1957 had not been accidental. The decision by James Klokow to come forward in 2008, more than 50 years after the events in question, is itself a significant element of this case. Whatever personal, familial, and emotional calculus went into that decision, its legal consequence was to set in motion a process that would result, 5 years later, in a criminal conviction. James Klokow's disclosure is an example of the role that family members with historical knowledge can play in reopening cold cases, a role that is increasingly recognized by law enforcement agencies and cold case units as a critical source of investigative leads. The legal challenges of prosecuting a case whose origins lay in 1957 were substantial and in several respects unique. The physical evidence from that era was, in many respects, unavailable or compromised by the passage of more than 50 years. The original investigation records, whatever their quality and completeness, represented the forensic standards of a very different era. Original witnesses from the 1957 investigation had, in many cases, died. The individuals with personal knowledge of the events were themselves elderly. The documentary record was limited. Despite those challenges, the Sheboygan County District Attorney's Office determined that the evidence available, including James Klokow's disclosures, any surviving documentation, and the other evidence developed in the course of the reopened investigation, was sufficient to support a criminal prosecution. Charges were filed against Ruby C. Klokow. The charge was second-degree murder. The decision to file a second-degree murder charge against an elderly woman for a crime allegedly committed more than 5 decades earlier was, as a matter of Wisconsin legal history, exceptional. It represented a determination by the Sheboygan County District Attorney's Office that the legal system retained both the authority and the obligation to pursue accountability for the death of Janine Klokow, regardless of the time that had passed. The case moved through the Sheboygan County Circuit Court system over the years that followed the 2008 reopening. Pretrial proceedings in a case of this age present unique challenges. Motions regarding the admissibility of historical evidence. Challenges to the reliability of testimony about events that occurred decades earlier, and legal arguments about the fairness of prosecuting conduct that was not charged at the time it allegedly occurred. The Sheboygan County Circuit Court navigated these issues as part of the normal pretrial process. In February 2013, 56 years after the events in question, Ruby C. Klokow entered a plea of no contest to the charge of second-degree murder in Sheboygan County Circuit Court. The no contest plea is a formal legal disposition in which the defendant does not admit guilt but acknowledges that the prosecution has sufficient evidence to obtain a conviction at trial. For purposes of sentencing, it is treated identically to a guilty plea. The entry of the no contest plea resolved the case without a trial. The sentencing proceeding in the Klokow case presented a unique legal complexity. The principle that punishment must be commensurate with the law as it existed at the time the crime was committed, not as it exists at the time of sentencing. This constitutional principle, commonly referred to as the prohibition against ex post facto punishment, is a foundational element of American criminal law. It means that a defendant cannot be sentenced under a more punitive legal framework than the one that was in place at the time of the offense, even if that framework has been significantly expanded in the intervening period. In the Klokow case, this principle meant that the Sheboygan County Circuit Court was required to apply the sentencing framework that Wisconsin law provided for second-degree murder in 1957. That framework was substantially more limited than the sentencing options available under contemporary Wisconsin law. The maximum sentence available under the 1957 statute for the charged offense was 10 years in state prison. Sentencing was conducted on May 1, 2013. The court imposed the maximum sentence, 10 years in state prison. The imposition of the maximum available sentence reflected both the court's determination of the appropriate punishment within the available range and the recognition that the conduct at issue, the death of a 6-month-old infant, was of the most serious nature, regardless of the age of the case. Ruby Klokow subsequently sought to avoid serving the full sentence through a petition for parole. That petition was denied. The court's determination that she served the sentence as imposed was upheld through the parole review process. The case of Ruby C. Klokow stands as one of the most remarkable cold case prosecutions in Wisconsin legal history. It demonstrates that the passage of time, even the passage of more than half a century, does not necessarily extinguish the legal system's ability and obligation to address conduct that caused the death of a child. It demonstrates the critical role that family members can play in bringing long-dormant cases to the attention of law enforcement, even when decades have passed. It illustrates the constitutional framework within which courts must operate when sentencing defendants for historical conduct. And it stands as a testament to the institutional willingness of the Sheboygan County legal system to commit to a prosecution that, by any conventional measure, presented extraordinary challenges. Janine Klokow was 6 months old in 1957. She did not receive the attention of the legal system in that year. She received it, imperfectly, within the constraints of the applicable law, and 56 years later, on May 1, 2013, in Sheboygan County Circuit Court. That is a long time. But the Sheboygan County Circuit Court record makes clear that the effort was made, the case was built, the plea was entered, and the sentence was imposed. In the world of cold case prosecution, that outcome, however long delayed, is significant. This case is one of Wisconsin's most extraordinary cold case prosecutions. If it moved you, please like this video and subscribe to Cold Case Hour. Drop a comment below, we read every single one. And share this episode with a true crime community near you. Case 6. Karin Luttinen. Town of Teresa, Dodge County. April 29, 2009. The case that follows is one that begins not with a crime scene in the traditional investigative sense, but with a discovery made in a wooded area in the town of Teresa, located in Dodge County, Wisconsin, on April 29, 2009. What was found that day was the remains of a newborn infant, wrapped and left in a garbage bag among the trees of a rural section of the town. The town of Teresa sits in western Dodge County, approximately 40 miles northwest of Milwaukee. It is a small, rural community, the kind of place where wooded areas and open land are common features of the landscape, and where something left in the woods might not be discovered for days, weeks, or longer. In this case, the discovery was made and reported to the Dodge County Sheriff's Office, which initiated an investigation. The infant was a girl. She had no name on record, no birth certificate on file, no family connection that law enforcement could immediately identify. She was, in the terminology that would come to define her public identity over the next 12 years, Baby Teresa, named for the town in which she was found. The Dodge County Sheriff's Office and the Wisconsin Division of Criminal Investigation were among the agencies that responded to the scene on April 29, 2009. The scene was processed as a potential crime scene. The infant's remains were submitted for forensic examination by the medical examiner's office. The investigation that followed encompassed the standard elements of an inquiry involving unidentified remains, documentation of the scene, collection of physical evidence, forensic pathological examination of the remains, and the initiation of efforts to identify the infant. The findings of the medical examiner's examination were medically and forensically significant in ways that shaped the direction of the legal case that would ultimately be brought. The medical examiner determined that the umbilical cord was wrapped around the infant's neck. Based on those findings and the overall physical examination, the medical examiner's determination was consistent with a fetal or stillbirth scenario, meaning the evidence did not definitively establish that the infant had been born alive, had survived birth, and had then been harmed by an external act. The cause of death could not be definitively determined to be homicide. This distinction between a child who died as a result of being abandoned after having been born alive and a child who was stillborn but whose birth and death were then concealed is legally significant. Wisconsin's criminal statutes address both scenarios, but through different charges and with different evidentiary requirements. In cases where the medical evidence supports a conclusion that the child may not have been born alive, the charge most directly applicable to the conduct is not homicide but concealment of death. Specifically, the act of concealing the death of a child and disposing of the remains without reporting the death to any legal authority. Under Wisconsin law, concealing the death of a child is a felony. The obligation to report the death of a child, regardless of whether that death was the result of criminal conduct, and to ensure that the child's remains are handled in accordance with law, is one that applies to the child's parents and to any person with knowledge of and control over the situation. The failure to meet that obligation, when it involves a deliberate act of concealment such as wrapping an infant's remains in a garbage bag and leaving them in the woods, is treated by Wisconsin law as a serious criminal matter. The problem faced by law enforcement in 2009 was not one of legal framework. The applicable charge was clear. The problem was identification. Law enforcement had baby Teresa. They did not have her mother. There was no record of a birth. There was no missing persons report. There was no hospital record. There was no connection to any identified individual that investigators could follow. The DNA profile of the infant could be generated, but without a match in any available database, it provided no identification. The case file remained open, but active investigative leads were exhausted. The case remained open for 12 years. During those 12 years, baby Teresa remained unidentified. Investigators in Dodge County retained the case file and the associated evidence. The DNA profile that had been developed remained on file, available for comparison if a relevant match should ever appear. But in the absence of such a match, and with no other leads to pursue, the active investigation was dormant. The resolution came through forensic genealogy, a methodology that had, during the 12 years that baby Teresa's case lay dormant, developed from a research technique into a powerful investigative tool. Forensic genealogy works by taking a DNA profile developed from biological evidence, in this case, from baby Teresa's remains, and submitting it for comparison against the consumer genetic genealogy databases that have been built up through services like GeneMatch and FamilyTree DNA. These databases contain the voluntary genetic submissions of millions of individuals who have submitted their DNA for genealogical research purposes. When the DNA profile from an unidentified individual is compared against these databases, it can produce partial matches, matches that indicate not a direct identification, but a family relationship. By working backward from those partial matches, forensic genealogists can construct family trees, identify candidate individuals, and ultimately narrow the field of possible identifications to a specific, named person. This methodology became nationally prominent through its application to the identification of the Golden State Killer in 2018. In the years following that high-profile success, law enforcement agencies across the United States, recognizing the power of the technique for cold cases involving unidentified remains, began applying forensic genealogy systematically to their most intractable unresolved cases. Wisconsin agencies were among those that adopted the methodology as part of their investigative toolkit. In the case of baby Teresa, forensic genealogy produced the identification that 12 years of traditional investigation had not been able to obtain. In 2021, the methodology led investigators to identify the infant's mother as Karin Luttinen, a woman associated with the Shorewood area of Milwaukee County at the time of the 2009 incident. The identification was followed by law enforcement contact with Luttinen, further investigation, and the preparation of charges. In March of 2022, nearly 13 years after the discovery of baby Teresa in the woods of Dodge County, Karin Luttinen was charged in Dodge County Circuit Court with concealing the death of a child. The charge was a felony. Prosecutors did not charge Luttinen with homicide, consistent with the medical examiner's findings that the evidence did not establish that the infant had been born alive. Karin Luttinen entered a plea of guilty to the charge of concealing the death of a child. The case was resolved through the guilty plea without proceeding to trial. The sentencing hearing was scheduled and conducted on September 16, 2022, in Dodge County Circuit Court. The court imposed a sentence of 3 years of probation, 6 months in jail, 60 hours of community service, and a monetary fine of $5,000. The sentence imposed in this case reflects the specific charge, concealment of death rather than homicide, and the medical evidence that shaped that charge. It is a sentence that the Dodge County Circuit Court determined to be appropriate given the full context of the case, including the medical examiner's findings, the nature of the specific offense, and the circumstances of the defendant. The case of Karin Luttinen and baby Teresa is significant in this documentary for several reasons. It illustrates the transformative power of forensic genealogy as an investigative tool, its ability to reach into cold cases that have resisted identification for years or decades and produce answers that no other available methodology could provide. It demonstrates the functioning of Wisconsin's legal framework around the concealment of infant death. It shows how the specific findings of a medical examiner shape the available legal response to a tragic situation. And it gives a name, even after 13 years, even posthumously, to a child who had been known only as baby Teresa throughout the investigation. Baby Teresa was found on April 29, 2009, in the town of Teresa, Dodge County, Wisconsin. She was identified through the application of forensic genealogy in 2021. The legal process concluded on September 16, 2022, with a guilty plea and sentence in Dodge County Circuit Court. She was unnamed for 12 years. The investigative work that gave her mother a name also, in a sense, gave her one. Baby Teresa's case is a powerful example of what modern forensic science can do. If this episode meant something to you, please like this video and subscribe to Cold Case Hour. Leave a comment below and share this with anyone who needs to hear these stories. Case 7. Dashja Turner. Racine County Circuit Court. July 31, 2023. Sentenced April 25, 2025. Racine is a city of approximately 77,000 people located in Racine County on the western shore of Lake Michigan, approximately 30 miles south of Milwaukee. It is the seat of Racine County government and the location of the Racine County Circuit Court, the court that would ultimately adjudicate the case that began on July 31, 2023, when law enforcement officers from the Racine Police Department responded to an address in the city. What officers encountered when they arrived at that address was a situation that required immediate action on multiple fronts. 5 children were discovered inside the residence. The children ranged in age from 14 months to 14 years, spanning nearly the entire range of childhood from near infancy to adolescence. The conditions in which the children were discovered, as documented by law enforcement and subsequently described in court filings and media reports, reflected a situation of serious and prolonged deprivation. The children were found in a basement area of the home. The physical conditions present in that space, as documented in the official record, included a severe lack of food, conditions inconsistent with adequate sanitation, extremely limited access to natural light, and physical conditions in each of the children consistent with extended deprivation of adequate care and nutrition. The documentation of those conditions by responding officers and subsequently by medical personnel who evaluated the children formed a critical element of the evidentiary foundation for the criminal case that followed. The immediate response involved both law enforcement and Child Protective Services. Child Protective Services personnel were called to the scene and involved in the assessment and removal of the children from the residence. All 5 children were taken from the home and provided with emergency medical evaluation and care. The medical assessments of the children produced findings that were incorporated into the evidentiary record of the subsequent criminal prosecution. Law enforcement's investigation of the circumstances that had led to the conditions discovered on July 31, 2023 was conducted by the Racine Police Department in coordination with the Racine County District Attorney's Office. The investigation focused on establishing the nature, extent, and duration of the conditions in which the children had been living. A criminal case involving child neglect requires more than documentation of the conditions found at the time of discovery. It requires the prosecution to establish that the conditions were the result of the defendant's conduct, specifically, of a failure to provide the basic necessities of life, and that the defendant knew or should have known that the conditions in which the children were living posed a risk of serious harm. The target of the investigation was Dashja Turner, identified as the mother of the 5 children found in the home. The legal theory advanced by the prosecution was that the conditions discovered on July 31, 2023 were not the result of an isolated incident or a brief period of crisis, but of an extended and sustained failure to provide adequate food, appropriate living conditions, adequate sanitation, and necessary supervision to minor children whose well-being was entirely the defendant's legal responsibility. Wisconsin's child neglect statutes impose on parents and legal guardians a duty of care toward the children in their custody. When that duty is violated in a manner that places children at risk of great bodily harm, the law provides for felony prosecution. Dashja Turner was charged with 5 felony counts of child neglect, 1 count for each of the 5 children, with the enhancement that the neglect had resulted in or created a risk of great bodily harm to the children. This is among the more serious versions of the child neglect charge available under Wisconsin statutes, reflecting legislative recognition that neglect of sufficient severity and duration, resulting in significant physical harm to children, warrants serious criminal consequences. The case proceeded through the Racine County Circuit Court over a period that extended from the July 2023 discovery through the spring of 2025. Pretrial proceedings involved the review and exchange of evidence, legal motions, and the negotiations that ultimately produced the plea resolution. In February 2025, approximately 19 months after the discovery of the children, Dashja Turner entered a plea of no contest to 3 of the original 5 felony counts of child neglect causing great bodily harm. The resolution of 3 of the 5 original counts through the plea, rather than all 5, is consistent with the standard practice of plea negotiations in which some charges are resolved while others may be modified or dismissed as part of the agreement. The sentencing hearing took place on April 25, 2025, in Racine County Circuit Court. The court imposed a sentence of 6 years in state prison, structured as 3 consecutive 2-year terms, one for each of the 3 counts of conviction. The consecutive structure of the sentence, as in the Moronez case, means that the terms are served one after the other rather than simultaneously, resulting in a total prison term of 6 years. The sentencing in the Turner case reflects the court's assessment of a case involving 5 children, prolonged neglect, and conditions that the medical evidence established as having caused significant physical harm. 6 years. The sentence imposed on April 25, 2025, is a period that the court determined to be appropriate given the totality of the circumstances. The case of Dashja Turner illustrates several dimensions of Wisconsin child welfare law and criminal prosecution that merit attention. First, it demonstrates the capacity of law enforcement to respond to discovery situations, circumstances in which the victims of neglect are found by first responders rather than being the subject of a prior report, and to build a successful criminal case around the conditions observed at the time of discovery, combined with the evidence of duration that the children's physical condition provides. Second, it reflects the calibration of Wisconsin's child neglect statutes, the distinction between neglect resulting in great bodily harm and lesser forms of neglect, and the significant sentencing difference that results from that distinction. Third, the case illustrates the essential and parallel role of child protective services in responding to situations of this nature. The criminal prosecution of Dashja Turner and the removal and placement of her 5 children were separate legal processes, governed by separate legal frameworks, and proceeding through separate court systems, the criminal court and the family court. The criminal case produced a prison sentence. The child welfare case produced placement decisions, services, and ongoing oversight designed to ensure the safety and well-being of the children going forward. Fourth, the case demonstrates the functioning of the Racine County legal system in managing a complex, multi-victim case from discovery through sentencing over a period of approximately 22 months. The patience and thoroughness required to bring a case of this nature to a formal legal resolution, through investigation, charging, pretrial proceedings, plea negotiation, and sentencing, is a reflection of the institutional capacity of Racine County's criminal justice infrastructure. The 5 children found in the basement on July 31, 2023, ranged from 14 months to 14 years old. The youngest was barely past infancy. The oldest was a teenager who had grown up entirely within the conditions that the court would later determine constituted criminal neglect. The gap between those 2 ages represents the full span of childhood, and the full span of the failure of care that the Racine County Circuit Court addressed in its April 25, 2025 sentencing of Dashja Turner to 6 years in state prison. If this case moved you, please take a moment to like this video and subscribe to Cold Case Hour. Your support helps us keep covering important Wisconsin stories. Don't forget to hit the bell so you never miss a new upload. Case 8, Tyana Putzlocker, Green Bay, Brown County, May 3, 2022. Sentenced, November 20, 2023. Green Bay is the 3rd largest city in Wisconsin, with a population of approximately 110,000 people. It is the county seat of Brown County, located in northeastern Wisconsin at the southern end of the body of water for which the city is named, a bay that connects to Lake Michigan through the Straits of Mackinac. Green Bay is perhaps best known nationally as the home of the Green Bay Packers, but its identity as a functioning city encompasses a broad range of residential communities, industries, and institutional services, including the Brown County Circuit Court, which serves as the primary trial court of general jurisdiction for the county. On May 3, 2022, the Green Bay Police Department responded to a call involving an 18-month-old child named Derek. Emergency medical services were also dispatched. Derek was transported to a medical facility. He did not survive. The cause of death established by medical examination was fentanyl poisoning, the result of exposure to fentanyl, a synthetic opioid of extraordinary potency, at a quantity sufficient to be fatal to a child of his age and size. To understand the legal case that followed, it is essential to understand something about fentanyl and why its presence in an environment occupied by young children is treated by Wisconsin law and by child welfare professionals nationwide as a matter of the most serious concern. Fentanyl is a synthetic opioid analgesic that was originally developed for the management of severe pain, particularly in cancer patients. It is, in its pharmaceutical form, a legitimate and valuable medical tool. But in its illicitly manufactured form, the form that has been at the center of the opioid overdose crisis that has affected communities across the United States over the past decade, it is extraordinarily dangerous. Fentanyl is estimated to be approximately 100 times more potent than morphine and approximately 50 times more potent than pharmaceutical-grade heroin. The quantity required to produce a fatal overdose in an adult is measured in micrograms, a microgram being 1/1,000,000th of a gram. For a toddler, the fatal quantity is even smaller. Fentanyl residue can be present on surfaces, in residue left by handling, and in the ambient environment of a space where the drug has been used or stored, in quantities that are invisible to the naked eye, but are sufficient to cause serious harm or death to a young child who comes into contact with a contaminated surface or object. This is why Wisconsin law, and the laws of many states, treat the knowing presence of fentanyl and other dangerous synthetic opioids in an environment where young children are being cared for as a form of criminal neglect when a child is harmed as a result. The duty of a caregiver to maintain a safe environment for a child in their care is not limited to the avoidance of obvious physical dangers. It encompasses the obligation to ensure that the child is not exposed to substances that pose an acute risk to the child's life. The investigation conducted by the Green Bay Police Department and Brown County prosecutors following Derek's death on May 3, 2022 established the specific circumstances of his exposure to fentanyl. The investigation identified Tyana Putzlocker as Derek's mother and as the individual legally responsible for his care at the time of the events. The investigation also established a significant and legally relevant piece of background information. Prior to May 3, 2022, Derek had been the subject of Child Protective Services intervention. Specifically, he had previously been removed from a care environment associated with Tyana Putzlocker due to documented concerns about drug endangerment. The removal was a formal Child Protective Services action, documented in the official records of the system. It reflected a prior determination by child welfare authorities that the environment in which Derek had been placed posed a risk to his safety. Derek had been returned to an environment associated with his family, reportedly through an action taken by the child's grandmother in circumstances that appeared to constitute a violation of the terms of his placement, on the same day as the events that led to his death. This piece of the factual record raises questions about the functioning of the child welfare system's monitoring and enforcement of placement conditions that are, as noted in the discussion of this case, beyond the scope of the criminal prosecution itself, but relevant to the broader understanding of how cases like this one occur. The charge brought against Tyana Putzlocker in Brown County Circuit Court was child neglect, in which the consequence was the death of the child, a Class C felony under Wisconsin statutes. The legal theory of the case was that Putzlocker's failure to maintain an environment for Derek that was free from the risk of fentanyl exposure constituted the criminal neglect that caused his death. The charge did not require the prosecution to prove that Putzlocker had intentionally exposed Derek to fentanyl. It required proof that she knew or should have known of the risk and failed to take the steps necessary to protect him from it. The case proceeded through the Brown County Circuit Court. After the investigation and pretrial proceedings, Tyana Putzlocker entered a plea of no contest to the charge of child neglect, where the consequence was death. Sentencing was conducted on November 20, 2023, approximately 18 and a half months after Derek's death on May 3, 2022. The Brown County Circuit Court imposed a sentence of 10 years in state prison, to be followed by 5 years of extended supervision. The total supervisory period of 15 years, the combination of the 10-year prison term and the 5-year extended supervision period, reflects the court's assessment of both the immediate conduct at issue and the ongoing need for supervision of Tyana Putzlocker following her release from confinement. Extended supervision in Wisconsin is a formal legal status that requires the supervised individual to comply with specific conditions set by the court and monitored by the Wisconsin Department of Corrections. Violations of extended supervision can result in reincarceration for the balance of the supervisory period. The 15-year combined supervisory commitment imposed in this case reflects a judicial determination that Derek's death, an 18-month-old child whose life ended as a result of fentanyl exposure, warranted a substantial period of both incarceration and post-release oversight. The case of Tyana Putzlocker exists within the broader context of Wisconsin's ongoing response to the opioid crisis, and specifically to the intersection of illegal drug activity and child welfare. Brown County, like many Wisconsin counties, has seen significant law enforcement and prosecutorial attention directed toward cases in which children are harmed as a result of the presence of fentanyl or other dangerous substances in care environments. The criminal statute applicable to these cases, child neglect causing death, has been used to address conduct that, while not involving intentional harm to a child, reflects a failure of caregiving so fundamental as to be criminal. Derek was 18 months old. He died on May 3, 2022, in Green Bay, Brown County, Wisconsin. His death was caused by fentanyl exposure in the environment in which he was being cared for. The person held legally responsible for that environment was sentenced on November 20, 2023 to 10 years in prison and 5 years of extended supervision by the Brown County Circuit Court. He was 18 months old. Please like this video and subscribe to Cold Case Hour for more verified, in-depth Wisconsin case coverage. Share this with your true crime community and drop a comment with your thoughts. Every single comment matters to us. Case 9, Nicole Gussert. Outagamie County Circuit Court. May 2017. Appleton is a city of approximately 77,000 people located in Outagamie County in east-central Wisconsin, situated along the Fox River in the heart of the Fox Cities metropolitan area. It is the most populous city in Outagamie County and serves as the seat of county government, including the Outagamie County Circuit Court. Appleton is a city with a strong community identity, a significant educational presence through Lawrence University, and a functioning network of social and health services that serves the needs of its residents. In May of 2017, the Appleton Police Department was called to a residence in the city in connection with the death of a 13-year-old child named Brianna Gussert. The circumstances that officers encountered when they responded to that call set in motion a criminal investigation and prosecution that would conclude nearly 3 years later. And that stands as one of the most sobering examples in this documentary of the specific vulnerability of children with severe disabilities. Brianna Gussert had a rare birth condition that had left her unable to walk or speak. She was entirely dependent on the care of those around her for every aspect of her daily life. She required assistance with feeding, with hygiene, with medical management, and with the full range of basic human needs that most people address independently and without conscious thought. She could not go to a neighbor's house and ask for help. She could not call a teacher or a social worker or a hotline. She could not write a note or send a message. She could not, in the most literal sense, advocate for herself in any way that might have brought her situation to the attention of someone outside the home. She was, in the most complete sense of the word, dependent in a way that far exceeded even the ordinary dependency of childhood, and dependent on a single adult whose legal responsibility as a parent was the primary mechanism society had put in place to ensure her safety. That adult was her mother, Nicole Gussert. When law enforcement and emergency services responded to the Appleton residence in May 2017, they found Brianna Gussert deceased. The medical examination that followed established the cause of death as sepsis. Sepsis is a serious medical condition. It is a life-threatening systemic response that occurs when an infection triggers a chain reaction throughout the body, potentially causing organ failure and death if not treated promptly and aggressively. It is a condition that develops over time, typically from an untreated infection that spreads. It is also a condition that, in the vast majority of cases in which it is identified and treated by medical professionals, responds to appropriate medical intervention. The critical element of Brianna Gussert's death from sepsis, in the context of this case, is the word untreated. Sepsis does not arrive without warning. The underlying infection that leads to sepsis, whatever its specific origin, produces symptoms that, in a child receiving regular medical attention and living in adequate conditions, would typically be identified and addressed before the infection could progress to a systemic, life-threatening level. Brianna's death from sepsis was, in the legal and medical analysis applied to this case, not simply the result of an infection. It was the result of an infection that was not addressed, not treated, not brought to the attention of medical professionals, in a child who was entirely dependent on her caregiver to recognize and respond to her medical needs. The investigation conducted by the Appleton Police Department and Outagamie County prosecutors documented in detail the conditions of the home and the circumstances of Brianna's care in the period leading up to her death. That documentation established what investigators and prosecutors characterized as a sustained failure to provide the care that Brianna required, a failure that encompassed multiple dimensions. The conditions of the home itself were documented as severely inadequate. The specific failures identified through the investigation included a lack of adequate food provision for Brianna, a failure to maintain the hygiene standards necessary for a child with her level of physical dependency, and, most directly causally related to her death, a failure to seek medical attention for a child who was showing signs of a serious and potentially treatable medical condition. The investigation additionally established that Nicole Gussert had been selling Brianna's prescription medications. This conduct was legally significant in two respects. First, it constituted a separate criminal offense under Wisconsin's drug statutes, the delivery of controlled substances. Second, it served as evidence of the specific character of the neglected issue, not merely a failure of attention or resources, but conduct that actively diverted from Brianna's benefit the medications that had been prescribed specifically for her care. Prescription medications for a child with Brianna's level of disability are, in the normal course of caregiving, managed by the parent or guardian for the child's benefit. They are obtained through the healthcare system on the basis of the child's documented medical needs. They are intended to support the child's health and quality of life. The decision to sell those medications, to convert them from a resource for Brianna's benefit into a source of personal income for her mother, is conduct that prosecutors characterized as emblematic of the broader failure of care. The charges filed in Outagamie County Circuit Court reflected both the death of Brianna and the drug-related conduct. Nicole Gussert was charged with child neglect causing death, a serious felony under Wisconsin law, and with drug delivery, specifically the delivery of controlled substances that had been prescribed for her daughter. Both charges were brought as felonies, reflecting the severity of the conduct and the significant harm that resulted. The case moved through the Outagamie County Circuit Court over the standard pretrial process. In February 2019, approximately 21 months after Brianna Gussert's death in May 2017, Nicole Gussert entered a plea of no contest to both charges. The entry of the no contest plea resolved both the neglect charge and the drug delivery charge without proceeding to trial. Sentencing followed the plea after a period in which the court reviewed the pre-sentence investigation report, received victim impact information, and considered the arguments of prosecution and defense counsel regarding the appropriate sentence. On March 5, 2020, Nicole Gussert appeared before the Outagamie County Circuit Court for the imposition of sentence. The court sentenced her to 17 years in state prison, to be followed by 12 years of extended supervision. The combined supervisory period of 29 years, 17 in prison and 12 on extended supervision, is among the more substantial sentencing outcomes in a Wisconsin child neglect prosecution in the period covered by this documentary. It reflects the court's assessment of the full gravity of the conduct, a prolonged failure to provide any of the fundamental necessities of care to a child who was completely unable to supplement or substitute for that care in any way, resulting in that child's death from a treatable condition, combined with the additional criminal conduct of selling the child's medications. The sentence also reflects a judicial recognition of the particular vulnerability of children with severe disabilities in situations of neglect. Brianna Gussert's inability to speak, to move independently, or to communicate her circumstances to anyone outside the home meant that the ordinary mechanisms through which child neglect comes to the attention of authorities, school attendance monitoring, reports from teachers and neighbors, the child's own disclosures, were entirely unavailable. She was invisible to the system, not because the system was not designed to protect children like her, but because her disability and her isolation combined to prevent any of the signals that might have triggered intervention from reaching anyone with the ability to act. The Outagamie County Circuit Court's imposition of a 17-year prison sentence and 12 years of extended supervision on March 5, 2020, was the legal system's formal response to a case that, in the estimation of the court, warranted sustained accountability. 29 years of total supervisory commitment, a span that extends to the middle of this century, is the legal system's answer to the question of how seriously Wisconsin takes the death of a dependent child through sustained neglect. Brianna Gussert was 13 years old. She had a rare birth condition that made her entirely dependent on her mother's care. She died in Appleton, Outagamie County, Wisconsin, in May 2017. The legal proceedings concluded on March 5, 2020, in Outagamie County Circuit Court. The sentence imposed that day will govern Nicole Gussert's liberty for decades to come. Brianna's name is in the court record of the Outagamie County Circuit Court. It should be in this documentary. It is. Brianna's case is one that deserves to be heard. If you found this episode important, please like this video and subscribe to Cold Case Hour. Your support is how these stories stay in the public conversation. So please share, comment, and never stop asking questions. Case 10, Brooke Seal. Freedom and Little Chute, Outagamie County. January 2024. The final case in this documentary takes place not in the mid-20th century, not in the 1980s or 90s, not in the early years of the 21st century, but in January of 2024, in the most recent period represented in this production's 10-case span. It takes place in Outagamie County, the same county as the Nicole Gussert case discussed in the previous segment, in communities that are part of the Fox Cities metropolitan area of East Central Wisconsin. And like Case 8, the prosecution of Tyana Putzlocker in Brown County, it exists within the ongoing public health and criminal justice context of the opioid crisis in Wisconsin and the specific, disproportionate danger that synthetic opioids, and fentanyl in particular, pose to young children. Rosalie Garcia was 2 years old. She lived in Outagamie County, in an area encompassing the communities of Freedom and Little Chute, smaller communities in the Fox Cities area located in close proximity to Appleton. In January 2024, Rosalie Garcia was found unresponsive. Emergency medical services responded. Rosalie was transported for emergency medical care. She did not survive. The cause of her death, established through medical examination, was fentanyl poisoning. The investigation that followed the death of Rosalie Garcia was conducted by law enforcement agencies in Outagamie County and referred to the Outagamie County District Attorney's Office for charging determination. The investigation focused on the circumstances in which a 2-year-old child had been exposed to a quantity of fentanyl sufficient to cause her death, and on the identification and legal accountability of the individuals responsible for the environment in which that exposure occurred. The investigation identified Brooke Seal as Rosalie's mother and as the primary individual responsible for the environment in which Rosalie had been present at the time of the exposure. The specific findings of the investigation, as established through the subsequent court proceedings, documented a set of circumstances involving both the presence of illegal drugs in the home and Seal's active engagement with the drug supply that was the source of those substances. Specifically, the investigation established that Brooke Seal had allowed an individual named Fahim Jones, identified by investigators as a drug dealer, to reside in the home where Rosalie was present. Law enforcement, in the course of searching the residence, located a backpack in the laundry room of the home. The backpack was found to contain a stolen firearm, ammunition, and more than 1,400 fentanyl pills. The presence of that quantity, over 1,400 individual doses of a substance lethal to toddlers in microgram amounts, in a household occupied by a 2-year-old child represents an acute and catastrophic safety failure. Additionally, investigators conducted a review of Brooke Seal's phone communications. The phone records contain messages that were presented by prosecutors as showing Seal attempting to purchase fentanyl from Fahim Jones less than 10 hours before Rosalie Garcia died. This communication evidence was a significant and distinctive element of the prosecution's case. It established not merely the passive presence of fentanyl in the household, not a situation in which the defendant was unaware of what was in the home, but an active, documented engagement with the drug supply that was the source of the substance present in the environment where Rosalie was living. The distinction between passive and active engagement with a drug supply, in the context of a child neglect prosecution, is legally and morally significant. The law does not require that a caregiver have known that a specific quantity of fentanyl would cause a specific child's death at a specific moment. It requires that the caregiver knew or should have known that the conditions they maintained, or allowed to exist, posed a serious risk of harm to the child in their care. The combination of a known drug dealer residing in the home, more than 1,400 fentanyl pills present in the residence, and documented attempts to purchase additional fentanyl established, in the prosecution's view, a level of knowing engagement with dangerous conditions that went well beyond inadvertent exposure. The legal proceedings against Brooke Seal in Outagamie County Circuit Court addressed two distinct areas of criminal liability. The first was Rosalie's death, addressed through the charge of child neglect where the consequence was death. The second was conduct that occurred after Seal was taken into custody following her arrest. She was charged with and convicted of introducing a prohibited article into the Outagamie County Jail by concealing a prohibited item on her person. This secondary charge, the jail smuggling offense, is distinct from the circumstances of Rosalie's death. It is conduct that occurred after the death in the county's detention facility, and it added a layer of accountability to the prosecution beyond the primary child neglect charge. The combination of the two felony charges, child neglect causing death in possession of an illegal article in a county jail, reflects the full scope of Seal's criminal liability as established through the investigation and legal process. Brooke Seal entered a plea of no contest to both felony charges. The plea was entered in Outagamie County Circuit Court and resolved both charges without proceeding to trial. Sentencing was scheduled following the entry of the plea and the preparation of the relevant pre-sentencing materials. The sentencing hearing was conducted on March 24, 2025, approximately 14 months after Rosalie Garcia's death in January 2024. The Outagamie County Circuit Court imposed a sentence of 9 years in state prison, to be followed by 8 years of extended supervision. The combined supervisory period of 17 years, 9 in prison and 8 on extended supervision, reflects the court's comprehensive assessment of the full scope of the conduct. The death of a 2-year-old child in circumstances tied to active illegal drug activity, combined with criminal conduct inside the county jail following arrest. 9 years in state prison, 8 years of extended supervision, a total of 17 years under the legal authority of the Wisconsin court system, beginning from the date of sentencing in March 2025 and extending, assuming no modifications, well into the early 2040s. The case of Brooke Seal and Rosalie Garcia exists within a specific and well-documented context. Outagamie County, like many Wisconsin counties, has seen the impact of the synthetic opioid crisis in its communities, its healthcare system, its child welfare system, and its criminal justice system. The cases that have come before the Outagamie County Circuit Court involving fentanyl and children, of which the Seal case is among the most recent and most serious, represent a category of prosecutions that has grown in frequency as fentanyl has become more widely available and more deeply embedded in the drug supply. The Wisconsin Department of Children and Families, the Outagamie County Department of Health and Human Services, and law enforcement agencies across the Fox Cities metropolitan area have all, in recent years, focused significant attention and resources on the intersection of drug activity and child welfare. The Seal prosecution represents one outcome of that focus, a criminal case built on thorough investigation, documentary evidence, physical evidence recovered from the home, and the cooperation of multiple law enforcement and prosecutorial professionals. Rosalie Garcia was 2 years old. She was found unresponsive in January 2024 in Outagamie County, Wisconsin. She died as a result of fentanyl poisoning. Her name appears in the records of the Outagamie County Circuit Court as the victim in a case that concluded on March 24, 2025, with a 9-year prison sentence and 8 years of extended supervision. It is worth pausing at the conclusion of this final case to note what 2 years old means. 2 years old is a child who has just begun to speak in sentences, a child who is learning to run rather than walk, who has started to form memories, who knows the faces of the people in their life and associates those faces with safety and comfort. A child who is entirely incapable of understanding risk, entirely incapable of self-protection, and entirely dependent on the adults around them to maintain an environment in which they are safe. Rosalie Garcia was that child. The Outagamie County Circuit Court, on March 24, 2025, imposed the legal consequences that Wisconsin law provides for the failure to maintain that environment. Rosalie's case is a reminder of how important these stories are to share. Please like this video, subscribe to Cold Case Hour, and leave a comment below. Your support keeps this channel running and keeps these children's names in the conversation where they belong. If you made it to the end of this documentary, thank you. Covering 10 verified Wisconsin cases with the accuracy and respect they deserve takes significant research and care. The only thing that makes it possible is you. So please, like this video. It takes 1 second and makes an enormous difference in how many people this episode reaches. Subscribe to Cold Case Hour if you have not already. Our commitment is to legal accuracy, victim dignity, and responsible journalism. Every case we cover is sourced from public records and verified reporting. We do not speculate. We do not sensationalize. We document. Hit the notification bell so you never miss a new episode, and leave a comment below telling us which of these 10 cases stood out to you most. We read every single one. Share this video with someone who needs to hear these stories. Every share means more people encounter them, and that the names of these children are remembered by more people. Justin Brunka, Brad Steege, Katie Kozaniecki, Erica Hill, Jada Clay, Oliver Hitchcock, Giannine Klokow, Baby Teresa, Derek, Brianna Gussert, Rosalie Garcia. They deserve to be remembered. That is what Cold Case Hour is here to do. We will see you in the next one.